Today we're unpacking a 2025 Supreme Court judgment that, it honestly reads like something straight out of a movie.
Well, it really does. You have this high-ranking jail officer, a prisoner transport, a getaway car.
And an attack with red chili powder. You can't make this stuff up.
You can't. But the real twist here, the thing that makes this case so important, is that the police initially said the officer was completely innocent.
They gave him a clean chit. So our deep dive today is into Gurdeep Singh versus the State of Punjab. It's all about how the courts can step in when it looks like a guardian of the law has become the villain.
Exactly. Let's get into the facts. It all goes down on November 30th, 2010.
Okay, so what's happening?
You have a prisoner, Gurdeep Singh, who's being transported back to jail. The normal procedure, the safe procedure, is to use an official police bus.
Right, standard protocol.
But the assistant superintendent of the jail, Gurdeep Singh, he personally intervenes. He tells the constables, let's skip the bus.
And take what instead?
A private car, a Tata Qualis, which is just the first massive red flag.
And it gets worse.
Much worse. He then allows two complete strangers to just hop into the back of the car with them.
Unbelievable. So they're driving along, and then what?
Then, on this really desolate stretch of road, Gurdeep tells the driver to pull over. He says he needs to answer a nature call.
Which was obviously the signal.
It had to be. The moment the car stops, those two strangers, they throw chili powder in the constable's eyes and just start stabbing them.
And the only reason the prisoner didn't escape was because he was handcuffed to one of the constable's belts.
A simple piece of hardware. That's all that stopped it. But look at Gurdeep's role in all this. While his men are being blinded and attacked, he allegedly does nothing.
He just flees, uninjured.
Exactly. Yet, after all that, the initial police inquiry clears him. They don't even charge him.
So this is where the law has to find a way back in. Let's talk about Section 319 of the Criminal Procedure Code.
This is such a critical tool. Section 319 basically says that a court is not bound by the police's initial investigation.
So even if the police say someone's innocent,
the court can, during the trial, look at the evidence being presented and say, wait a minute, this person's name keeps coming up, their involvement seems clear.
And they can summon them to face trial as an accused.
Precisely. It's a fundamental check on power, ensuring that a clean chit from investigators isn't the final word.
Okay, so the court uses 319 to pull them into the trial. But then you have the problem of proof. How do you prove conspiracy? It's not like they had a written agreement.
Right, you rarely get direct evidence of a conspiracy, of that meeting of minds. So the Supreme Court had to rely on Section 120B of the Penal Code.
Which is about inferring the agreement from the circumstances.
Exactly. You look at the whole chain of events, his conduct became the evidence.
Insisting on the private car.
Letting the strangers in, picking that specific spot to stop.
And his complete inaction during the attack.
The court said his actions were just completely inconsistent with being a dutiful officer and totally consistent with being a co-conspirator. But the prosecution still had one more hurdle.
The witnesses.
The hostile witness problem. The driver and one of the constables, they suddenly changed their stories in court.
Which happens a lot when a powerful person is in the dock. So what did the court do?
Well, this is where Section 134 of the Evidence Act is so important. There's a principle that says evidence is weighed, not counted.
Meaning one really good, credible witness is better than a dozen who are less than truthful.
You've got it. The court put all its faith to the testimony of the one injured constable who stuck to his story. They decided his single, truthful account outweighed the others. Quality over quantity.
It's just a powerful reminder that a police clearance isn't bulletproof. The judiciary has the tools to correct the course if the evidence points that way.
It really does. And, it leaves us with a really tough question to think about.
Go on.
When a guardian of the law, someone with a badge, uses their authority to actually help a crime happen, is that betrayal of public trust maybe even more damaging than the violence itself?
That's the big question. Thanks for listening to this deep dive. Stay curious.